We have Stuart Alderodi, Chief Legal Officer at Ripple. He's now calling for an investigation after the release of the much anticipated Hinman documents earlier this week. Welcome to the show, Stuart.
Oh, happy to be here. Thank you.
We are happy to have you. So first, before we dive deep into this, let's take a step back for anyone who might have missed what's going on, who might not been following the news. Explain to us what the Hinman documents are and why this was an important piece of the case against Ripple.
Sure. So I'm just sort of go back to square one very quickly. In December of 2020, the SEC filed an enforcement action against Ripple, alleging that our distributions of a digital asset known as XRP should have been registered with the SEC as a security. In December of 2020, that may have, been, we may have felt that we were kind of alone on an island on that, but fast forward to 2023, and I think everybody understands that this is an incredibly important policy issue that needs to be resolved in the U.S. But we have fought the SEC, and we have fought them very hard because we believe they're wrong. And if the policymakers are not going to stand up and give us a policy solution, we're going to have to turn to the courts to get that solution. And we fought to get internal emails and communications at the SEC about their thinking on this topic. And the seminal speech that was given in 2018 by the former director of corporation finance, Bill Hinman, where he announced that a digital asset can morph from a security to a non-security based on a standard that he had made up. We now have uncovered internal discussions within the SEC before that speech was given. And what we have learned is that Bill Hinman was told by senior officials at the SEC, their own general counsel and their head of trading and markets, among others, that his speech was not following the law, that he was making things up. He would create greater confusion in an already confused market, and he was exposing a regulatory gap that the SEC probably didn't have the power to fill. And the SEC has taken that speech, they've touted that speech, it's still on their website today, and they've weaponized it to bring a series of enforcement actions and trying through regulation by enforcement, we now know, to really destroy and disrupt this crypto economy in the United States.
Stuart, is this what you expected to uncover in these documents?
Yeah, now we have seen, we got access to these documents last year, and the judge has seen them. The new news here is the judge on her seventh court order relating to these documents said that the public deserves to see these documents. But yes, this corroborates a number of very important, relevant things, or things that are relevant to our case. One, that when the law is faithfully applied, when you faithfully apply the statute in the famous 1946 Supreme Court case known as Howey, the SEC has no case. Two, it confirms that the SEC fostered regulatory confusion in the marketplace. They knew the marketplace was confused, and they took steps to deliberately aggravate that confusion. And I think that goes to what's known as the fair notice defense, that folks of ordinary intelligence did not have fair notice about how the SEC was going to apply what they believe to be the law to this industry. And lastly, we shouldn't forget that in addition to suing Ripple, the SEC in December of 2020, I think as a last-ditch effort to bring maximum leverage on the company, sued our founder and our CEO personally, alleging that they were reckless in allowing Ripple to distribute the digital asset XRP in the way they did. And to establish recklessness, you have to prove that the individual either knew or recklessly disregarded what the law was. And we've now confirmed that that is an outrageous allegation, because at best, the SEC were debating internally what the law was. At worst, they knew what the law was, and they distorted the law to create this confusion in the marketplace.
So, Stuart, the reaction to this has been somewhat mixed. Not the market isn't entirely seeing these documents as like the smoking gun that it might be perceived as. And I've seen some comments on Twitter saying, "Oh, this doesn't really prove anything. This is not, this doesn't really change anything." And then the price of XRP, which I know you're not here to comment on, but still hasn't reacted that positively to just this reveal. What are the critics missing here? I mean, why do you think that's happening? Why are people not kind of seeing the significance of these documents in the same way that Ripple sees them?
Yeah, look, I think these documents are a bit of a Rorschach test. I think people will look at them and want to find what they want to find. What I'm most concerned with is, what does the court think? What does the judge think? And we don't know what the judge ultimately will think, but we do know that the judge believes that these documents are relevant to the case, which is why she compelled the SEC to produce them in the first case. And we know that she felt it was important for the public to see these documents because she considers these documents what's known as judicial documents, documents that she will likely rely on or refer to when she writes her decision. So that's what's important to us.
On the topic of the critics, critics have long argued that Ethereum and XRP are comparably decentralized. It's like that's a debatable argument. What's your response to those critics?
The XRP ledger is open, permissionless, decentralized. It has always been. So that is not at issue. I think what is at issue is whether the concept of decentralization is a technological standard, which I believe it is, rather than a legal standard that the SEC tried to make it to be. And I think the reason they tried to make decentralization a legal standard is because they find the legal standard to be inconvenient. They find it inconvenient to have to prove a contract for an investment. They find it inconvenient to have to prove a common enterprise. They even find it inconvenient to have to prove that somebody actually invested money as opposed to digital assets being given or granted. So I think decentralization as a technological standard is an important discussion for the industry to have, in the XRP ledger, under any definition of decentralization, is decentralized. As a legal standard, I think we need to faithfully apply the law.
So, Stuart, in a way, Ripple was kind of a pioneer in this sort of battle against the SEC. Now you have a lot of comrades, kind of a lot of tokens are being, targeted by the SEC. Are you seeing any? I'm just curious. Are any of these projects reaching out to you? Is there any kind of like collaboration? People asking for advice? Are you seeing any kind of unity here now that there are so many tokens that might soon be facing similar situations?
I think that's a great point. As I said, in December of 2020, when we were sued a couple of days before Christmas, so a really nice, personal touch from the SEC, we said from day one that we were going to defend this case not only on our own behalf, but we were going to defend this case on behalf of the entire crypto industry in the United States. I'm not sure everyone believed us in December of 2020, and some were outspoken and said they didn't believe us in December of 2020. As I said, sitting here in June of 2023, everyone believes us. Everyone understands how important this fight is. And in many ways, Ripple, in a perverse way, we've actually been benefited by the SEC suing us when they did, because we're at the end of our journey and others are at the beginning of their litigation journey with the SEC. But I think if you look at the defenses and the narrative around what some of the actors who are now on the wrong side of the V with the SEC, they are reading from the Ripple playbook, and that is perfectly fine with us.
Well, on that topic, we must bring up the two recent lawsuits that we've been talking about for the last 2 weeks, the SEC versus Coinbase and Binance. You're expecting a result in your case, I think, by the end of September. How do you think that the result of the Ripple case, or even the revelation of the Hinman documents, might be of aid to Coinbase or Binance as they fight their own legal battle?
Look, I think transparency is an important thing. I think that it is really disheartening as a lawyer, as an American, that we have a regulatory agency that is fighting so hard to hide the truth. And in using, again, deliberate creation of confusion and chaos as a weapon. They weaponize regulation by enforcement. So anything that can shine a bright light on the SEC's tactics here, I think is a very good thing. I think exposing that the SEC themselves identified a regulatory gap in the space that they themselves understood they probably didn't have the authority to fill is a really important revelation. People forget sometimes that these agencies only have the power that is granted to them by Congress, and they answer to Congress. They can't create law. They have to apply the law, and they have to apply the law faithfully, and the SEC has woefully failed to do that. So I think that will give other industry players that now find themselves in a courtroom with the SEC a leg up to start with. And obviously, the substantive application of the law is very, very important. And as we get clarity in the courts, I think the knock-on effects of that will prove to be beneficial to others who find themselves in this position.
So, Stuart, one interesting data point here, which I think not that many Americans know, or I mean, I'm sure the XRP fans know, but just like how big XRP is in overseas markets, right? Like, I mean, Korea and Japan, I mean, there's just huge communities there. And so I guess my question for you is, has Ripple run into any legal problems in any country outside of the United States? I mean, or is it really just the US that you're dealing with this question? Because, I mean, XRP is all over the world.
It is just the US. There's only one country in the world, and in fact, there's only one regulator in one country in the world that has ever suggested that XRP should be registered as a security, and that's the SEC in the United States of America. No other country has taken that position. In fact, other countries have affirmatively taken the opposite position. We have over 800 employees at Ripple. They are dispersed throughout the world, not only in the US, but in Singapore, in London, in Ireland, in Brazil, in Dubai. In all of those jurisdictions, we work very closely with regulatory agencies, getting appropriate licenses, getting appropriate regulatory oversight over our business, which, as you know, is to facilitate cross-border payments for financial institutions and banks. So our customers are enterprise, not retail. And what those regulators are concerned with are consumer protection, protecting the integrity of the market, and doing our best to keep bad actors out of this industry. And they're creating regulatory frameworks where those important goals can be accomplished without crushing the innovation and technology that underlies the industry. Unfortunately, in the US, this regulator under this leadership, and actually under the prior leadership, is hell-bent on destroying this crypto economy. So what's going to happen? And we're seeing it. And over the past 2.5 years, we've been forced to grow our business outside of the U.S. And our most successful 2 years in our 10-year history as a company has come in the last 2 years. And all of that growth has come outside of the U.S. And I think others are starting to learn their lesson. And we're starting to see this technology, this innovation, this entrepreneurial, the entrepreneurs that back it, tax dollars, jobs, all of that is going to leave the U.S. And I think, we need to wake up, because it's 2023, and 10 or 15 years from now, we're going to probably see the bring the crypto back to the U.S. Act, like we've just seen with the CHIPS Act. We're losing an incredible opportunity here. The U.S. is a leader, and we're not only, I don't think we're losing our leadership position, I think we've lost our leadership position.
Stuart, thank you very much for joining us this morning and providing that insight into your case.
Great. Happy. Thank you. Happy to join you.
That was Stuart Alderoty, Chief Legal Officer at Ripple.